Okay, okay, there we are. There we are. Welcome to everybody who is here in person, and also welcome to folks who are tuning in for our teaching for tonight. We're just pleased that each of you is joining us here at New Horizon Rankin, and we bless God's wonderful name. Tonight, we continue in our series on estate planning and using the book, okay, Learning to Trust. Our teacher for this, not only tonight, but across this series of teachings is Dr. Sabrina Edmon Williams, and she has done just a fabulous job of this, and we're very, very excited about this teaching and this training. And so she continues tonight. In fact, there's a few special things that's going to take place in addition to that tonight, and so we're in for even more a great treat. For everybody who may be tuning in online, once again, welcome to each one of you tonight, and want to remind you that you can, if you were not here last week or some of the other sessions, you can go back on the site and pick those up. We would encourage you also, if you do not have a book, please get a book. You can get an electronic copy, or you can order one of the books, the hardbacks themselves, okay? But that's a great tool, and we want to encourage you to do that as well. So thank you for joining us. With that, help me welcome our teacher, Dr. Sabrina Edmon Williams.
Thank you. Thank you, Bishop. Thank you. I appreciate that introduction. How is everyone tonight? All righty. Can y'all believe we are at week 6 already? That is just amazing to me. I mean, the time just flies. I guess we'll say when you're having a good time, time flies, right? So we have talked about a lot. And tonight we're going to talk about taking action. And we're not just going to talk about it. We're going to be about it. All right? All right. Let the church say amen. Amen. All right. So for those who, let's see, let's get this going here. Uh-oh. Okay. So for those who are just tuning in, we know that everybody here in the live audience knows who I am, but for those who may be tuning in for the first time, I am Dr. Sabrina Edmon Williams, educator, author, and investor, opening minds and closing contracts. Y'all supposed to say it with me. Now we've been saying it for 6 weeks. Repeat it back. I am so noted, and I am also a life and legacy planning strategist, okay? So that means I'm the person that has been given the responsibility, and it's playing the role, Bishop, my role, of helping to educate the community on the importance of estate planning, and not just estate planning, building, protecting, and properly transferring wealth, okay? I got to give this disclaimer. So y'all do know this one because we've been saying this one for 6 weeks now. I am not a JD. I am and the information that we are giving is for educational purposes. That's right. That's right. Educational purposes. I tell you, I walked into the studio there at the radio station this morning. I had to go drop something off, and one of my attorney friends was there in the booth, and I tell you, I walked in, he stopped mid-sentence. Oh, who is that? What's she doing? What's she doing? So I had to be real careful how I move now. I don't want to step on anybody's toes. So we're going to keep this thing going. Now, week 1, we started this course. Remember, we got to go way back now. Week 1, we talked about what it took to get organized. Because anytime we're doing anything, the first thing that we have to do is get organized. That makes it so much easier, right? Getting organized. So once we got organized, we decided we need to take some inventory. That was week 2, taking inventory of what we have. We know we're supposed to pass on a legacy, an inheritance for our children's children, but if we don't know what we have, we don't know what we're going to pass forward, right? So we took inventory week 2. Week 3, we started talking about what happens in the instances that you don't die, but you become, what's that word, Daddy? Incapacitated. You become incapacitated. So we started talking about advanced care planning. And then week 4, we talked about, well, what happens if we do die? Somebody has to pay for our final expenses. So we got into that. Week 5, last week, we talked about that whole concept of succession. Okay? Succession. Who comes behind us in those roles? See, Bishop, I was listening to you. We know we have roles within our family, and that is very important, especially in the black family. So we talked about that concept of succession. Now, this week, it's time to take action because we've been talking we're doing a whole lot of talking. Now it's time to take action. So, upon completion of this course, look at that, I forgot to update that slide. Y'all didn't see that, so I'm going to keep going. Upon completion of this course, we're going to really be ready to go to the next level and take some action. Now, just by way of review, we know that estate planning is both what? The preparation of our assets so that we can transfer them upon our death, as well as if we should become incapacitated. But now I'm going to walk this. I had this idea. So y'all going to walk with me, right? We're going to walk this thing out. This is how it happens every time. I promise this is how it happens. So first thing we do, we get that call. Sometimes it's in the middle of the night. Sometimes it's in the morning. Sometimes it can be at the noonday. We get that call. I know which one I'm talking about. We get the news, right? And then, of course, everybody is shocked and, we're real close and everybody's hugging and consoling each other. But then when we start thinking about that next step, we got to bury the person. That's when the group text goes out and, people start contacting folks and we start having a conversation. Y'all know which one I'm talking about, right? And so quickly, things start looking like this. Yeah, we don't want to talk. It gets a little tense. What you mean I got to pay? And usually it's about what? This, right? It's about this. But after we meet with the funeral directors and they make it clear that if there's no this, there's no this, we get it together, right? We get it together. And if we can make it through this and get to this, all right? I know the people, on the audio, they're in the audience, they're like, what is she talking about? This. If we can get beyond the funeral and putting the person in the ground, then what's next? What happens next? Come on, y'all know it. Everybody has had it in their families. What's next? It looks like this, doesn't it? We start tussling, particularly over the house and the land and the stuff, the car, the stuff, right? This is what it looks like. So tonight, we're going to talk about how to transfer property upon our death. Now, specifically, we are going to be talking about real property, land, houses, that kind of stuff. Okay, that's what our primary focus is going to be on. But we will touch upon some other things. So, option number 1, you die, you put nothing in place, you just check out. And you say, hey, I'm gone, it's not my problem, y'all figure it out. I'm dead, I'm gone. But you can't take any of it with you, right? So it's going to transfer. When you die like that, that's called leaving things interstate, dying interstate, meaning you had no will, no plan, and guess what? No instructions means somebody gets to decide what happens, right? And usually, who makes that decision about your estate? A judge within your state, right? So when you have no estate plan, your state plans what happens to your estate. Okay? Now, one of the things about doing that, and I think we touched on this in one of our other lessons, is we create an issue that literally is destroying wealth within the black community. Anybody remember what it's called? Heirs property. When you die and you don't designate a particular individual to receive or become the beneficiary of your estate, you create an heirs property issue. And this is what it looks like graphically, okay? So let's just say we had a grandfather, and the grandfather had land perhaps, right? Now it was titled in grandpa's name, but grandpa didn't decide or determine anybody to leave the land to. Grandpa had some heirs. Grandpa in this illustration had 5 heirs. So guess what? Each one of those heirs has an interest in that property, but it doesn't really outright belong to any of them, right? But they all have an interest in it. Now, I've had this conversation. I think my dad and I, we solve all the world's problems. When he's driving and I'm driving, we get on the phone and we just solve all the world's problems. One of the things that we talked about, I think yesterday, was this whole concept of how is it that our grandparents with limited education could go get the land, no money, but they maintain the taxes. Yet, they have 5, 6, 7, 8, 10, 12 kids, you name it, pick the number. And it's a struggle. It's a struggle, and this is what it looks like. So, grandpa at the top, no will, no instructions on who gets what. Now, if grandpa has 2 children or 2 heirs, of course, they each share 50%. Okay, well, let's say each one of them have 2 children. So when one passes, their share is then, their 50% share is divided in half. So you got 50% over here and 50% over there, but it's divided into 2 on this side. So there's 25 and 25 and 50 over here. Well, when this person on the right passes on, their 50% is then divided among their heirs. And this cycle continues and continues and continues and continues. And the pie is getting thinner and thinner and thinner. Everybody's piece of the pie is getting smaller. And this is when the confusion starts right here, right? Because you got all those people on that bottom row, and still they can't maintain the property taxes. Somebody asked me the question the other day, said, well, Dr. Williams, is it that they can't do it or they won't do it? Won't do it. Okay? But we see how this is an issue. And the reality is we have many options for transferring property. And that's what we're going to talk about tonight. Option number 2. Now, we know that first option, doing nothing, that is an option, but that's not a good option. Okay? And we just spent 6 weeks now educating ourselves, so we're going to do better. So I need your commitment. Everybody in this room, option 1 is not an option, right? It's not an option. Okay, option number 2, create what most of us have heard of, a last will and testament. Last will and testament. And this is a better option than option number 1. However, it has a few drawbacks, and it is good for some people. Now, if you are, see this baby here, if you are a parent and you have a child that needs a guardian, yes, you do. need a will because you do designate or identify your guardian within your will. So that is a good option for you. That doesn't have to be your only option, but this is what you need to do. I'm just going to be honest with you. You do need to designate that. Now, the problem, can somebody talk to me? Tell me what the problem is with the will option. We talked about it. Okay, there's my star student. I was waiting for him to show up. It's called probate. Absolutely. Probate. That's a bad word. That's the P word. It's a bad word. Probate. If at all possible, we want to avoid it. Why? Because it can be costly, it can be time consuming, and it can be downright messy. Really can. It can be messy. How can it be messy, Dr. Williams? Well, let's just say, y'all remember that song by the Temptations? Dun 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 dun. Papa was a rolling stone. You know, Papa mess around and die, and Papa have a lot of heirs out there that we don't know about. Probate could get pretty messy, couldn't it? It could get real ugly. And sometimes some of the, as we call them, the outside kids are just waiting for Papa to die to get their share. So probate can get really ugly. I'm talking about the issues we have in our community. I'm just keeping it real. These are the issues we have in our community, okay? So we got to think about that. How can we avoid this? Now let's talk about that process and what it looks like. So again, we talk about the authentication of the will in the instance where you have a will. Now, of course, if you don't have a will, there is no authentication of the will. So that's just determining whether you actually wrote it. Is it valid? Did you sign it? You know, is that your signature? Did somebody forge it? Okay? So once they determine that it is authentic, then, of course, we look at who your representative is. Okay, with the will, we have 3 parties involved. One being who? No. With a will, 3 people. Anybody know? The person who dies, okay. The beneficiary, that's 2. Not a will. Executor, right? The trustor or the grantor, the person who is actually putting their things into the will, okay? Then the executor. What's the role of the executor? What do they do? All right, to manage. They oversee the distribution. They make sure that what you put on that paper is what happens with your assets. That's their role. And then the beneficiary, that's the person who receives. We know what who the beneficiary is. We know that role, right? Okay. So appointing the personal representative or identifying them. Identifying and notifying creditors. Remember, when we talked about estates and identifying what an estate is, we said it's what you own and what you owe. Okay? So they got to notify the people and let them know that you are no longer of this world. And you may have a few assets. So they determine the value of the assets that you had on your passing. They're at the date of your passing, locating those things. Are they all in one state? Do you have assets in multiple states? We got to figure out what you have so that people can get paid, okay? After the payment, now, the creditors want to, no, we got to start at the beginning. The funeral home is the first person that's going to get paid. Otherwise, you're not going in the ground. Sorry, it's not happening. Okay, they got hip. After they get paid, then, of course, who gets paid? Creditors. Who else has to get paid? Creditors, another C. The creditors and the court. The court, the attorneys that that represent you in this process. And then who else gets paid? Nothing is certain except for who? 2 things. What is it? Death and taxes. So you've already died. What's left? taxes, that last tax form has to be filed. They get you coming and going, I tell you. That I and that R and that S, they get you coming and going. So that last tax form has to be filed. And if they have things called estate taxes and inheritance taxes. And I think for most of us sitting in this room, we probably don't have to worry about any of that because your estate has to be over. I think right now it's up to $13.1 million before you start paying estate tax. Anybody in that tax break, in that category? Anybody? All right. I just wanted to see if I could hold a little something. that was you. Sadly not. We don't have those kind of problems around here. So, and then Mississippi doesn't have the other taxes. So we're good there, okay? And then if there's anything left, that's when we get to the distribution part, okay? So you see how that process works, and anywhere along this path here, we could run into some problems. Okay, so we want to avoid that if possible. Now, option number 3. That's my preferred option. I know I'm the trust person. Wrote a book about trust. Okay, so just like you have 3 people involved with that will, you have 3 people or entities involved with the trust. Okay, the first of those being who? Who would you think? Trust who? You can read. You sit there. The trustor, settlor, or grantor. Those are all the same entity, okay? You may hear them called different things. The settlor, that's the person who actually creates the trust or has the things that they're, entrusting to someone. And then who's the second entity? Begins with a T as well, the trustee. What role does that person serve? Pretty much the management function, pretty similar to the executor. So they have a management function, okay? And then who are they managing it for? The benefit of the beneficiary, okay? And we know who those individuals are. Those are the people that we love and that we want to benefit from our estate. Now, I am of the mindset that most of us would benefit from some form of a trust, okay? One of the things that I want to make clear is trust can be very complicated, but we're going to make it simple because all of them have this in common. They fall into 2 broad categories. They're going to either be revocable or irrevocable. Now, make it simple for you. A revocable means you can amend it, you can change it, you can modify the terms of the trust, okay? Irrevocable means you can't. Once you set it, that's it. For the most part, there are a few circumstances under which that may change, but for the most part, it's just that's what you do, okay? Now, somebody might say, well, why would you not want to be able to change it? Well, each one of them offers certain benefits, okay? So it depends on what you're trying to accomplish, which one of these categories you would fall into and which way you would go. So both of them, let's talk about what they have in common. Both of them are going to allow you to avoid that nasty P word, probate, okay? Both of them give you a certain level of privacy, okay? So we won't have folks Google searching how much you left your son or your daughter or your charity, whoever you leave your stuff to, because that will and that court proceeding is public. So literally somebody could go and Google search what you did. And if you're fine with that, you're fine with that, okay? I'm not suggesting, if you're fine with that, but just know that that is possible, okay? And, of course, both of them are ways to transfer your asset, estate planning purposes. But that irrevocable offers 3 features that revocable does not, okay? If you are a person that, let's say you're a higher income earner, and you may be looking for some type of tax planning strategy, you may want to look at an irrevocable trust. because there are certain things that you can do with an irrevocable from a tax planning standpoint that you can't with the revocable. Okay? So that's one of the advantages. We've talked about advanced care planning, Medicare planning, long-term care planning. There are some things that you can do within an irrevocable trust that you cannot with a revocable. And the reason why that is because with the revocable, you're basically giving up control of your assets. Okay? They are no longer yours, really. They belong to the trust at that point. Okay? Go back and read the book. I talk about that, and I use OJ as my example in there and those assets, okay? Then the last one is asset protection. So let's say you got into a car accident, God forbid, and somebody decided to sue you, and they won, got a judgment, large judgment against you. Well, if you have a lot of assets, somebody could actually claim those as part of that settlement, right? But if you don't own anything, they can't take what you don't own. Think about that. I don't own it. The trust owns it. I am not the trust. Okay? So that's a distinction that you can make with an irrevocable trust. There is a line of separation. With a revocable trust, not so much, okay? With an irrevocable trust, there is an extra tax filing, 1041, not just a 1040. With the revocable trust, there is no additional tax filing requirement. So when you file your 1040, that's it, okay? However, with an irrevocable, there is an annual tax filing requirement. So somebody asked me, well, Dr. Williams, somebody created a trust for me, and I'm not really sure if I have a revocable or irrevocable. I asked that question. Are you filing a separate tax form? No. Well, you don't have an irrevocable. Yeah, because you would have to do that. So that's just a simple way to distinguish the two. We can get into a very long conversation, but we don't have a lot of time. But I did want to point out those things and just know that the one that's the better one for you really does depend on what you're trying to accomplish, okay? So I had a lady that I'm working with that's 86 years old, okay? She lives in the family home. Once she passes on, the home will revert back to the family. So she's not concerned about, passing on her home to her child, but she is concerned about making sure that he does not receive a lump sum of money at one time. She wants to make sure she has something in place so that it is dispersed to him at intervals because she does not feel that he could manage a large sum. So for her, the type of trust that would make sense is probably different than what would make sense for maybe me or even maybe you, okay? So that being said, benefits of the trust, of course, we know we are trying to avoid probate. We are trying to make sure that we are putting something in place to distribute our assets to our loved ones as we want them distributed. That's something that we're not necessarily able to do with the will that distinguishes. And with that trust, a trust can actually be managed while you are alive, okay? It goes into effect when it's created, whereas your will goes into effect when you die. You have to die in order for it to go into effect, okay? Now, there are a few other options for transferring your real property. By real property, do you guys understand what I mean when I say real property? Real estate, okay? All right. So, anybody ever heard of a life estate? Can you guys still hear me? I feel like I'm, okay. Life estate, anybody? Heard of a life estate? So, a life estate is basically a form of a deed which basically allows you to determine who can live in a property for an extended period of time, and usually it's their lifetime, and then how it transfers upon their death. So you have what's called a life tenant, okay? That life tenant stays in the property until they die. Once they die, then your beneficiary or your remainder man takes over, okay? It transfers to that individual. So when would something like this be a good idea, maybe? Anybody think of a situation? Perhaps a remarriage, okay? Think about that. You had a house before you got married. You remarried someone and you passed before them. You don't want to put them out. You want them to have somewhere to stay until they pass on, but you don't want the property to go to them once they're gone, right? You don't want it to go to maybe their heirs. You want it to revert back to your heirs. So you could set up a life estate. Let the person stay there for the duration of their life with instructions that the house reverts to whomever you designate. Maybe your children, your grandchildren, whomever you designate. So that may be ideal for something like that. Another situation I was thinking about, you know how sometimes we have maybe elderly parents and we have one child that will say, I'll put my life on hold. I'll go home and take care of mom and dad. I'm going to make the sacrifice. Well, that may be a situation where you set up a life estate where once that person, the parents pass on, the family home is available for that person for their life. And then once they pass on, it reverts back to the family. So there are a lot of different dynamics, especially within our community, where a life estate may be an option, but we got to know that these options exist, okay? So a life estate. Now, here's another one for transferring property. It's called a TOD, or a transfer on death deed. Transfer on death deed, which basically means when I die, my house transfers over to whomever I have listed. Now, who would this might possibly be ideal for? Can somebody think of a demographic that this may be ideal for? How about Granny? How about Granny? Granny may not have anything except for her house, right? Granny may not have a lot in terms of assets, but Granny has the family home, and Granny may have one child that she wants to have that home, okay? So this may be something that's ideal. Just go get a transfer on death deed so the Granny's house doesn't get caught up in probate, it doesn't become heirs property, and it transfers, okay? So that may be something to consider. Are we doing questions? Since the bishop asked the question, I will address that one. Okay, so let's assume, and here's the thing, and I'm glad you mentioned that because I do want to make a point here on that. I think it's time out for us feeling obligated just because we have multiple children. It doesn't have to. Who wrote that? Who said that? Go read the Bible. Go read the Bible. I see a whole lot of stuff transferring in the Bible. And they didn't say, well, just because I gave this one, this, I got to give this one the same thing. No. We make up those rules. We impose those rules on ourselves. Well, it may be ideal to leave one child the house. It may be ideal to leave another child a car or some money or something else. But we don't have to. We don't have to. We don't have to. We don't have to do that, but we do that. And a lot of times that is what creates those heirs property issues. So if you know, and I go back to this, we know our children. If you have more than one, you know them. You know who is going to be financially responsible, and you know who's not going to be financially responsible. You already know. You know who's most likely to take care of the family home. You know who's most likely to pay the taxes. You know. You know because you know how they treat you. They don't pay you. You already know. Think about that. Before they get paid, they calling you to ask to borrow some money. You know? So, I mean, we got to really think about not feeling obligated to just do that. It's called stewardship. And that's part of our stewardship to know, you know? Okay. Option 6. This is another. These next two terms, I want you to write them down, and I want you to go home if you own property and look at your deeds, okay? So, option 6, joint tenants with rights of survivorship. Joint tenants with rights of survivorship, okay? Here's the definition. This is a legal ownership structure pertaining to joint accounts, which basically says both of our names are on these accounts. If you pass on, then I 100% own the account. We 50% on the account because we're joint owners. But if you pass, I own it outright. I get your share of ownership. Okay? So you may have a deed, because if I ask that question right now, most of us would say, I don't know if my deed is set up as a joint tenants with the rights of survivorship. Now, chances are, if we're married, it probably is, okay? But what's the alternative to this one? Anybody know? Joint tenants are, listen to Miss Alice back there. Miss Alice got that right. She said it's called tenants in common. Joint tenants with rights of survivorship are tenants in common. So what's the difference between the two? What's the difference? Okay, so the bishop said that. I did not say that. Bishop said, okay, no, not so much common. So it's how your percentage transfers. So if I am joint tenants with you, a joint ownership with you, and you pass on or I pass on, we survive each other and we get that person's share, Miss Susan. So we own it together. You die, I get your share. However, when we're tenants in common, if you pass on, who gets your share? Your beneficiaries, Jim, thank you. They get your share. Now, this could create a very sticky situation in some instances. And I go back to somebody who said it in marriage. Was that what you, Miss Alice, that said marriage, okay? Let's say it's a second marriage. And you have your business structure like this. It may be a pro, it may not be a pro, okay? Think about a situation where your new husband and your children don't really get along very well. So if you pass, now they are tenants in common in the same property with your new husband. That may not be a good situation to leave them in. Now, in some people's, minds, maybe that is a good situation to leave them in because that may ensure that they have, benefit from your estate in some way. Maybe another way of approaching that might be that life estate, especially if it's something that you pre-owned. Understand what I'm saying? If it's not something that you guys bought or purchased together. If you owned it before the marriage and you wanted to stay within your family, you may want to look at another option because that could get messy. So you've seen that in church? Okay. Yeah. So, the reason why we bring this up because you do see these things. And a lot of time these terminologies on these legal documents, if we don't understand the ramifications, what they mean and what it's saying, that may not have ever been our intent to help create that type of situation. But because we did not understand the difference between the two, and somebody just put something on a piece of paper and we signed it, that's what we create for ourselves. So it's good to know the difference. Okay? Now, option number 7. There are certain beneficiary only documents, things like life insurance. Okay, that's not something that goes through probate. Now, there's something I want to bring to your attention, and I'm going to challenge you to do this. If you have any accounts where they are considered beneficiary type accounts, please go home and check them, especially in situations where you may be in a second marriage, you've had someone to die that could still be listed as your beneficiary. It's important. Divorced, please go look at these things. This is how a lot of people make some mistakes. They forget that they listed their ex-wife on the life insurance policy. And then they pass, and the new wife gets nothing. Nothing except the bill from the funeral home. Happened with aunt. Look, yeah, it happens. We know this. That's because people they forget. I read and actually I think I had this posted on my Facebook page from long time ago. There was a situation where somebody did that. And they weren't even married. The guy was dating this lady. He listed her as his beneficiary on his life insurance. He passed away, and guess what? He forgot to change it after they broke up. Now, they had broken up. They had been separate for years and years and years. But when he passed away, and the lady got wind that he was deceased, yeah, she got the proceeds. And the family tried to sue. They were very upset, but there was nothing that could be done because that was on him. That could be very messy. You know? And especially if you have a new spouse or if you have children. That's again why a trust is something that you really should consider, because there are instances when you can name your trust and when you should name your trust as the beneficiary of that life insurance policy, so that the money stays in the trust and is distributed out to your beneficiaries according to your instructions. Yeah, that may be a better option for some people. Okay? But that's the biggest point that I wanted to make about these beneficiary only type ways of transferring. And this is typically money, not necessarily real property. But just be mindful that if we do not change these documents, and we talked about that POD, and everybody has already done that, right? We went happily to the bank and made sure we had those beneficiary designations on the bank accounts, right? So that's an easy something that we can do. Easy something. Did you get your picture? I'm sorry. So I have a question. With all of these options that we just talked about, like 7 different options for transferring our assets, why in the world are we leaving our business like this? We leaving folks fighting over stuff. I just want to sit there right there in your spirit. Why? And if we have done that in the past, it's time to cut it out. Because now that we know better, what are we supposed to do? Do better. That's word. Hearing and doing. We've talked about it now for 6 weeks. Estate planning. We need to do it. We know not when we will fall ill and we will need that health care directive. Or when we are incapacitated and we will need someone to step in as power of attorney. Or when we will pass And we will need to make sure we have a plan for properly transferring our assets to our loved ones. We've heard. We've heard. So now it's time to be doers of the word. Again, we know we're now into November, but October was what month? National Estate Planning Awareness Month. And I promise I rang the alarm all month. So much so that one time I thought I wasn't going to be able to talk anymore. I did so much teaching. One week I taught Tuesday night, Wednesday night, Thursday night, and somebody wanted me to do something on Friday night. I said, I can't do it. Just trying to ring the alarm because this is something that we need to take more serious. We see what's going on in our community. We see what's going on in our land. People are leaving this world. You just said, Pastor Joe, for those that were not here during prayer time, sometimes people just wander away. Just wander away. So we need to have some plans in place. Now, not anytime soon. Next time, next year. Mhm. 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 And the reality is, you guys, right? The reality is, and I want to say this in all seriousness. The idea of having to deal with our own mortality is not easy. It's not easy. I get it. I get it. But because we love our families, and it's really about them and not putting them in situations where we don't have anything, any plans. We have to think about, somebody said, it's so hard, the idea of planning my own funeral. Well, it's hard for you, but what about your baby? What about that baby that's trying to grieve you and make decisions about, well, what color dress would mama have wanted to be buried in? I wish she have wanted a memorial versus a full funeral. I wish she have wanted to be cremated versus having a funeral. I wish she have wanted Bishop to bring words over her versus Pastor Joe. Or what song would she have wanted sung at the You leaving all of that on your children who simply just want to grieve. Think about it. But we talk about and we think about what's so hard for us. It's not about us. It's about those that we love, that we leave behind. Think about decisions that have to be made about our health. Anything could happen. You go out here, you leave tonight, you get in a car accident, you find yourself in a comatose state. Your family know? Do you want to be on the machines? When do you want the plug pulled? If you have not left any instructions behind, people are having to guess at what you would have wanted. So yes, it's difficult for each one of us, but it's difficult for other people too. And I already told you, if you have more than one child, they are not going to agree. They are not going to agree. Mama wanted life support. No, mama didn't want life support. Dad want, no, there is no agreement. In fact, we were on a call last Thursday night. One of my friends works at the VA, and she said they literally had to put some folks out the VA, a bishop, over some coins. The man had some coins in a jug, and the family got coins in a Crown Royal bag. And they got to fussing over the Crown Royal bag, and them people at the VA had to escort them on up out of there. Who was going to get the coins that they thought were gold coins in the Crown Royal bag? I mean, just, it's laughable, but the reality is we have seen it. We continue to see it over and over in our community. And it all boils down to the same thing. We don't have any plans in place. If I tell you, this is what I want, and this is how I would have wanted it, and this is who I wanted to have it, What y'all got to fuss about? And if you get mad, I'm dead. So what? I'm gone. That's your problem. So we've got to do more to position our families properly. And think about it like that. Let's position them so that they can grieve. Let's call it that instead of estate planning. We're positioning our families. Okay? So we've talked about this tool for organization. Now, my intentions were to bring some paper in here. And I started trying to print, and lo and behold, Freddie, one of the things, he's retired now officially. So I got this honeydew list that's about this long, and one of the items on my honeydew list is to figure out why my printer keeps printing with the line straight down the middle. So I have my computer with me tonight. If there is anyone who has not gone to the site and signed up for your free account, and you need your healthcare directive and your power of attorney, I do have my computer tonight. It takes us about 10 whole minutes to generate it. I can't print it, but we can generate it. I can print it out and bring it back. If anyone is here that has their documents with them already, Miss Susan, did you bring your stamp? Okay, we got the notary in place. Remember, the title of this section tonight, the session was what? Taking action. So if you need that, we are here to help you get it done, okay? All right, again, consultations are available if you need to talk. I'll tell you now, my 15 minutes usually turns into more like 30, sometimes 45, so go ahead and plan accordingly. Hint to the wise. Then we do have the resources available. Now, we're coming up on the holiday season. Again, please, we encourage you. Let's continue trying to get the word out, to use this book as a resource. I have given you what God gave me. He gave it to me for whatever reason, and I gave it to you just like he gave it to me. Now, when I wrote that book, I thought I was really just kind of talking about my family, but then when people started reading it, they told me, well, Dr. Williams, you sound like you were talking about mine. How did you know? How you know? We were dealing with all that. So I guess, it doesn't matter what street it's on, whose home it's on, what family name you call it. We all have some things in common when it comes to this issue of estate planning, and that's that we don't do it or we're not doing it properly. So I encourage you, please use this book as a resource. It is a good way to start a very difficult conversation. We are also offering, for those that are in the online audience, we also do Zoom classes, Zoom meetings for families, for groups. If we need to do that for you, I am here. My contact information across all platforms, I am so noted. IAMSEWNOTED. I am so noted. We're ramping up. We're wrapping up 2025, and we're actually ramping up for 2026. So we've already started getting requests. In fact, I got one on the way here tonight, Bishop. Somebody asked me, do you speak to church groups? Yeah, I do. I do. So we are getting requests. We've already started adding events on the calendar for 2026. And if we can help in any way, it is our absolute honor to do so. Now, that being said, what I would like to do after Bishop closes us out, I want to shift for just a second. I will entertain a few discussion points. Okay, we're going to shift for just a second, and then I'll set up in the back if anybody needs the healthcare directive and power of attorney. We can create those tonight, and it doesn't take us long to do it. Okay? All right, Bishop, Oh, yes. I'm so happy that you mentioned that. So, are y'all tired of me yet? Can I talk for just a little bit long? So there is something that is really troubling me, you guys. I have seen this technology, and I think technology is a great thing. I am a math and science major, so I think technology is a great thing, but it is also concerning. So we have spent 6 weeks talking about, our estates and how to properly transfer them. But my concern is the things that are out there that can easily persuade us, influence us in ways that could be detrimental to our estates. We're living in this era of artificial intelligence, and it's getting very, very difficult to distinguish the real from the fake. So there are a lot of online schemes and scams that are out there, and I would like for us to, I'd like to lead that discussion next week, because it would be a shame for us to do what we need to do to protect our estates, and then somebody, literally show up and swindle, convince the judge that they be the baby pappy, or something, and they walk away with my daddy's estate. Y'all saw that. What was that from Life? Y'all saw it. Okay, y'all did see that movie, right? Okay, I have to ask. But that's, in all seriousness, there is a case that I read about out of Georgia, you guys, and I have this video on my YouTube page where a guy did go in pretending to be someone's heir and convinced the judge, and guess what? Walked away with the estate. That's a real thing. Yeah, real thing. So we want to talk about that next week, and I think that's going to take us to the week, not prior to Thanksgiving. So it's just next week. Next week is the week prior to Thanksgiving? Oh, okay. So if you don't mind, please come on back and be part of that discussion, because we definitely want to protect ourselves and protect our estates, okay? All right, Bishop.
Wonderful, wonderful job again from Dr. Williams, and thank you. You're helping us all. For those that are here present, and certainly for everybody that's watching as well, then listen. As the scripture says, don't just be a hearer, but you got to be a doer. That's what it's been the whole time, but especially tonight, that's been the whole point, that you got to do something about what you have heard. And so don't put it off. That's the other side, okay? Don't put this off. Listen, we've got one more week, okay, of this, and so please tune in or be here for the final week, and we're going to end with a bang, okay? It's been wonderful, but we're going to bring it to a close, all right? And so we're looking forward to it, and just looking forward to getting our house in order, okay? That's what it's all about. Once again, for everybody, particularly online, we appreciate everybody tuning in here at New Horizon Rankin, and we invite you, if you're anywhere in the vicinity, to come and worship with us any Sunday at 11 a.m. For everybody who's here, thank y'all for being out tonight. With that, Father, bless, you already are blessing, but bless even more us as we prepare to leave this place. Be with us, give us traveling mercies and grace, and cause us, God, to do something with what we are receiving. Bless your people, whether they are here physically or they are out there in virtual land. In Christ Jesus' name we pray. Amen. Hey, y'all have a great night. You're dismissed. Oh, yeah. Okay, well, so that's stopped for that. So the video, the virtual stuff is stopped. Daryl, so come.